Hi, Simon. How are you?
Good, Maya. Thank you. How are you?
I'm fine, thank you. It's always nice to see you. It's been a while since
Indeed, it
we
has. Nice to
last.
see you too.
Yeah, it's very nice to see you. I always learn so much from you when I talk to you because you are probably, from my end, the only person I know who practices in this very specific and niche area, which is parole hearings. And lately, we've been hearing a lot about parole because there was a very
Mhm.
high profile case, even though it's an American case. The Menendez Brothers case was in the news. And I don't think there was ever that much of an interest in a parole hearing as we've witnessed during this case. So, and it raised a lot of interesting questions about parole hearings. And it just made me realize personally that there was so much that I didn't know about parole. And I thought, well, from a Canadian perspective, there's no one better than you, Simon Borys, to tell us more about parole hearings because I think that there is an interest in knowing more about these types of hearings. So let's start with what is parole and why do we have parole hearings in the first place?
Sure, sure. Thanks. I think that's a good place to start to understand sort of philosophically, like what is this and why do we have it?
Mhm.
Because there's a lot of misconceptions about what parole is. So I think the starting point is to recognize that um, almost everybody who is convicted of a crime and sentenced to a period of time in custody as a sentence for that crime is going to be back in the community at some point. Certainly, everybody serving a finite sentence is, and many, if not probably most, at some point in their life, of people who are serving life sentences will also end up back in the community on some form of parole. So, given that reality, it makes sense to have a system that allows them to reintegrate in a gradual, supervised, and supported way. This is good for public safety. As a principle, this is good for public safety. And in addition to that, there are economic reasons why parole makes sense because it costs a lot of money to incarcerate people
Hmm.
in the prison system. Tens of thousands of dollars per inmate per year. And that's the reality. And it doesn't make sense financially from like a societal perspective to pay for that unnecessarily. What do I mean by unnecessarily? Well, if a person's risk of offending is manageable in the community, and that is essentially the legal test for parole, and we can get into that more later, but if a person's risk of offending is manageable, well, then shouldn't we want them in the community where we're not paying for it anywhere? So, I mean, there are both sort of public safety reasons and financial reasons why parole makes sense, and so I think that's the starting point for this. And then the next thing is that I think it's important for people to understand that getting parole is not mean getting like your sentence ended early. It is just transferring the location you are serving this sentence from in a custodial facility to serving this sentence in the community. But the person is still very much under sentence until they reach their warrant expiry date, which is like the end of their sentence. If you got a
Hmm.
5 year sentence, 60 months down the road is your warrant expiry date. And if you have a life sentence, you have no warrant expiry date. It is the date of your death. And so you will be, serving this sentence either in a custodial facility or in the community for the rest of your life. And so that's important to understand because it's not the same as just getting out and being free. Being on parole is not being free. There are many restrictions that a person has. There are obligations they have to comply with. They have supervision from their parole officer. They have meetings they have to attend to. They have to request permission for lots of things. And frankly, that's what I'm talking about in terms of a gradual, supervised, and supported reintegration into the community. So, um, I think it's important to understand that that's what it is, and it's not some kind of get out of jail free card, and certainly not for reasons of sympathy or we're soft on crime or something like that. I mean, again, this only happens when the parole board has been able to assess this person's risk of offending as manageable. Now, I mean, they may not always get that right. People get released, they reoffend. I mean, it happens. But you wouldn't want a system where there was no such thing as parole, because then when those people are done their sentence, they're just going to get back into the community with no supervision and no support. And that is very much contrary to public safety. So I think that this is like a safe and economical thing to have. So,
And
I mean, I think that's what I would want people to know about parole at the outset.
And it happens at a specific time, right? Like you're not going to be eligible for parole before a certain period of time. And this is something that maybe we can mention, Simon, because a lot of people always want to know, well, when is a person eligible for
Yeah.
paroling?
Right, exactly. So, I mean, parole is a balancing act between the fact that we want to give people some amount of time to reintegrate into the community, but we also want them to serve some amount of time in prison
Exactly. Yeah.
before they're eligible. Like the sentence has to have some
Yeah.
bite to it.
Yeah.
We don't just sort of say, well, you've been convicted of a crime, your risk is manageable now, therefore you just immediately go on
Yeah.
to parole. That would
Yeah.
not be the
There's
right
always
balancing.
going to be some real jail for
Absolutely.
some time. And then at some point we start. So like if we want to just quantify, when does that start?
Yeah, for sure. So I mean the it's a little bit different in different contexts. So,
Hmm.
for example, in this country, we incarcerate people who are serving sentences of 2 years less a day, so 1 day less than 2 years, or anything less than that, in the provincial jail system. That's
Hmm.
where they go to serve that sentence, and we call that a provincial sentence.
Yeah.
And those people are subject to provincial parole before the Ontario Parole Board. And then you have people serving sentences of 2 years or more, and they go and serve that time in the federal prison or
Hmm.
penitentiary system, and they are subject to federal parole, and they appear in front of the Parole Board of Canada for parole. So there's two parole schemes depending on whether it's provincial or federal, and they are slightly different. But generally speaking, a person is eligible for parole at 1/3 of their sentence.
Hmm.
There's a qualifier in the federal system that a person is eligible for day parole, which is a form of parole where you live in a halfway house in the community as opposed to going home at 1/3, which would use what you'd be eligible for. A person's eligible for day parole in the federal system only. There's no day parole in provincial. 6 months prior to their 1/3, or a minimum of 6 months. So, for example, anyone serving a sentence of 2 to 3 years, their day parole eligibility, that's what we call it for the halfway house, is at 6 months, not 1/3 less six. Anything more than 3 years, it's 1/3 less six is their day parole eligibility. And then the other type of parole, which we call full parole in the federal system, is at 1/3. And in the provincial system, there's only the full parole option. There's no
Right.
day parole. And it's at 1/3, just like it is in the federal system. So essentially, after 1/3 of your sentence, sometimes a little earlier for day parole in federal, that's when you're eligible for trying to go for this form of discretionary release, this discretionary parole. And that's what we call parole, sometimes referred to as early parole, but really that's just sort of another way of saying parole. And then the other important thing to consider is what happens at 2/3 of a person's sentence. Because that's where, in the federal system anyway, you have essentially a mandatory form of parole, which is called statutory release. So when a person serving a federal sentence reaches 2/3 of their sentence, it's not a discretionary form of release where you have to convince the parole board that your risk is manageable. Like the statute, the Corrections and Conditional Release Act, operates to essentially put you out on parole
It's almost like a
for that
reverse
last
onus kind of like
it's sort of like a reverse onus. The way it works is that the statutory release is automatic, subject to the fact that the Correctional Service of Canada can refer cases to the parole board for something called a detention hearing, which is when they think that a person should not be released at 2/3 of their sentence because they are too high a risk, like risk of offending, especially violently, and then they can refer that case to the parole board, who will convene a hearing to determine if that person should in fact be detained. In other words, if their risk is not manageable. So it's a presumptive release, but it's by no means like guaranteed for all people, including those who are like a violent risk of offending, or a risk of offending violently, I should say. Those people can still be captured by this detention protocol and kept in custody, which is a bit of a double-edged sword, because when those
yeah.
people reach their warrant expiry dates, they will be out in the community, and they'll have had no period of supervision or reintegration. So again, it's a bit of a double-edged sword, but that's essentially the way it works. That's the balancing is generally speaking, 1/3 of your sentence, you're going to do that. That's part of your punishment and your separation from society. Then you become eligible for parole at some point between, you don't have to go for it right at 1/3. Oftentimes, it's not until sometime after that a person gets their parole hearing organized. For example, if they're delaying to complete programming, rehabilitative programming, that might be a thing that causes them to delay. And then 2/3, again, we sort of force everybody out, subject to those being detained by referral to the parole board, because we want them to have, even those people, to have some period of time in the community where they can be supervised and monitored as they reintegrate. So
So,
in a nutshell,
yeah.
that's how the timing works.
So let's talk now then about the parole hearing itself and what is it that the board is looking for and what are the factors that they consider. And I'm just going to say specifically here, going back again to the Menendez Brothers case, one of the things I thought personally was I thought was shocking. I don't know if this is normal in parole hearings. It's how far back are they able to go and dig into a person's past to just go and look at some old behaviors and take that into account to determine whether or not a person should be released? Because in the Menendez brothers case, in specifically, what we saw is that they went back and they went back to some youth robberies that they did when they were 14. The guys are like in their 50s now. So is that relevant? How much weight does it have? And how far back can they go and dig into a person's past, Simon?
Yeah, that's a good question. So, um, the legal test for parole for both the provincial and federal comes from Section 102 of the Corrections and Conditional Release Act. And there's sort
Hmm.
of two parts to the test. The first part, which is really where all the heavy lifting happens, is has to do with the person's risk of offending. So the statute uses language that the person's risk can't be undue by being in the community. And so really what that means, like, colloquially speaking, is that their risk has to be manageable in the community, right? That doesn't mean zero risk. Nobody is no risk of offending, whether they've committed crimes before or not. We all have the potential to do that. So that's not the standard. The standard is that their risk has to be manageable in the community on the form of parole they're asking for, right? Because risk is obviously context specific or context dependent. And so, a person's risk might be manageable in one setting or on one type of parole and maybe not in another setting or another type of parole, depending on like what crimes they committed, where they came from, where they have negative associates. So, I mean, it is, again, very context specific. But that's the first part of the legal test, having to do with assessing the risk of offending and that risk needing to be manageable. And then the second part of the legal test is that the person's release on parole would contribute to the protection of society by facilitating their reintegration as a law-abiding citizen. And I think, in my experience, almost universally, that is just accepted as a foregone conclusion that, of course, it will contribute to the protection of society by facilitating their reintegration as a law-abiding citizen, because letting them out in this graduated form of release where they have supervision and structure is something that is good for public safety. It allows the person to be monitored. It allows the person to be supported in ways that are going to help ensure that they don't reoffend. So, I mean, I've never had a case where somebody's risk was assessed as manageable, but somehow they were denied because their release into the community wouldn't contribute to the protection of society by facilitating their reintegration. I mean, that is the nature of parole. It is to facilitate reintegration in a gradual kind of way. So, nothing, hearings don't really turn on that second part, but it is part of the legal test. Really,
Hmm.
hearings turn on the issue of manageability of risk. So then the question is, how does the board assess risk of offending? They take a very broad view of a person and how they got here and where they're going. So that means that the board will look at a person's past. That includes any prior criminal offending, but it also includes a person's family history, social history, upbringing, background. Like, how did they get to this point in their life that they were committing their index offense? That's the offense they're serving time for. All of that is relevant and fair game for the board to talk about. So that's one issue, or one part of a parole hearing, is to dig into a person's past. The second is to talk about their index offense itself. I mean, obviously, what
Right.
happened and why it happened is a very important part, a big part of any
I mean,
parole
that's
hearing.
why th're in prison. It's
Exactly.
yeah.
Right. And then the third thing that the board will look at is the person's time in the institution, both positively and negatively. So positively would mean rehabilitative programs, good behavior, employment in the institution, things like that. And negatively might mean if they've gotten misconducts or had further charges while they've been in or
Yeah.
things like that. And then the fourth thing that the board will look at is the person's release plan, right? To assess like what is the context in which we have to assess their risk. Are they going to a good place? Are they supported? Do they have counseling lined up? Do they have a job? I mean, all of these are things that are going to help the board
So
assess
I'm
this
just,
person's
sorry, I
risk.
just
For
have
sure.
to interrupt you here because I always find this very frustrating on when they're going to get out, what kind of release plan. How can they expect, especially if we're talking about someone who's been serving a very long sentence, 10 years, 14 years, how do you expect them to go out after so much time in prison, have, I don't know, an apartment waiting for them, a job opportunity waiting for them? I mean, it just sounds a little bit unrealistic, especially when we're talking about longer sentences. I understand if it's
Yeah.
just a few months or less than a year or a few years, but when it's longer ones,
Mhm.
how does that make sense though?
Yeah, I mean that's a good question, and certainly there are challenges with establishing a release plan when you are still in custody. I mean, I think that it's important to understand that most people who get released out of the institution, at least now we're talking the federal institution, prison
Yeah,
system, prison sentences
yeah,
of longer than 2 years. Those most people coming out of the federal system will go to a halfway house first. So there isn't really an expectation that they, especially say lifers, people who've been in for
yeah.
decades, that they
Hmm.
will have anything lined up. That's why we have halfway houses. It's a very integral part of the parole system that we have these halfway houses that are run by community agencies like John Howard Society or St. Leonard's Society or Elizabeth Fry Society that run these halfway houses with funding from the government and work in partnership with the Correctional Service of Canada and the Parole Board to provide places, transitional housing places for people to live while they work on getting their life established again, and then maybe moving on after a period of time on day parole, living at a halfway house to establishing their own residence and maybe transitioning to that after they've shown that they can do it successfully living in a halfway house. So it's for a lot of people, especially on longer sentences, it's by no means expected that they would be able to establish these
Yeah.
things fully and get out into the
Hmm.
community and just be on their own and be fine. That's not
Yeah.
really the way that it works. And there's certainly, as I said, a lot of challenges with respect to, finding employment. I mean, that's difficult when you have a criminal record. It's even more difficult if you're trying to do it while you're still in custody. You can't set up job interviews or things like that.
And
So, I
convicted
mean,
of murder. I mean,
yeah, it's a very very difficult thing. But there are organizations that do inreach into prisons to help people start the ball rolling on these things. A person can seek temporary absences from the federal prison system for rehabilitative purposes or release planning purposes. So that might be to go out into the community and visit Service Ontario and get a driver's license because they haven't had one in 3 decades. That is a valid purpose to give someone a short temporary release into the community to start working on things that will allow them to reintegrate properly into society. So there are opportunities within the system and with the assistance of external agencies that do inreach into prisons to support people who are going through this. And that's particularly relevant to those serving life sentences or very long sentences. And then obviously, a lot of people still do have family support, and a lot comes from that as well, that they'll help them get set up with counseling or a job offer through a friend or family member. That's probably more so with people serving shorter sentences because the longer you're in there, the more of your support structure falls away over time. But yeah, I mean, it's definitely not expected that everybody will be ready to hit the ground running and return to whatever semblance of a life they had before they were incarcerated or even something better without those baby steps like going to a halfway house and
okay.
having temporary absences.
So then they look at the person's history. So the
Yes.
factors or the things that they look at is the person's history, the circumstances of the index offense, like
Hmm.
obviously how serious it was, how bad, if it was like if they killed someone or there were injuries,
Sure.
how a number of victims, I
Yeah.
guess,
Yep.
how their conduct or misconducts in the past, criminal history in the past. They also look at what options they have in the future, but they also will look at their conduct during the time that they're incarcerated. Now, this is where it also is tricky. It's just very tricky. Like the whole thing is tricky, I find, when it comes to determining whether or not they should be released or eligible for parole. Because the challenge that we always hear from our clients is this whole prison culture where you kind of have to you it's very difficult to survive jail without getting into some kind of misconduct. Almost no inmate is going to be able to survive without having a fight, a single fight, or getting into some kind of problem because it's very harsh conditions. People have to defend themselves, and it's a very specific culture there, and they have to do things sometimes that they may not necessarily want to do, but they have to do in order to survive.
Yeah.
And yet the parole board is gonna evaluate how they were behaving or misbehaving during the time that they were incarcerated. So how do they balance that? Like
Yeah.
this is a tough
So
situation.
I think it is a difficult situation for people in prison. I mean, I would say there's very few cases out of the many hundreds of parole hearings that I've done, well north of 500, that I've had clients get to that point in their sentence where they've got absolutely no blemishes on their
Yeah,
record whatsoever. It's very uncommon.
almost
Classic
impossible.
examples of this are, somebody might be muscled by other inmates to hold some contraband or brew
Hmm.
or something like that in their cell with the threat of physical violence if
Yeah.
they don't. I mean, most people will just accept that, and instead of taking a beating or going to the guards and reporting it, which is going to get you a beating anyway, they'll probably just store it. So if there's a search and it's found, this person gets written up for possession of contraband, right? Another example would be like if a range in a federal prison is having a problem with officers or with something that's going on, they may put blockers up on their cell door windows to prevent officers from seeing inside, which means they can't do their count and count the inmates and make sure they're all still alive. That requires calling down a correctional manager, and that's what the inmates want, sort of a form of protest to get a supervisor down there so they can address some issue that's going on, say between the inmates and the staff. If you are an inmate on that range and you don't put your blocker up and the rest of your range does, again, you're going to get a beating. So I can very much understand how people will do these things to just go along and get along and preserve their safety in a very difficult and dangerous environment. Now, fortunately, so those are going to show up as misconducts on their
Hmm.
record, right? Those are
Yeah.
institutional disciplinary charges that you can get and get convicted for within the prison disciplinary court system and be punished for. And those will show up on your record, and that's something that the parole board will see and something that they will consider. Now, fortunately, I think the parole board, at least these days, maybe this wasn't always the case. Maybe I don't think it was the case when I started practicing this 15 years ago, but certainly I think is the case now that the board, they understand this. They are not blind to the realities of prison. They understand it is not a tea party and that things like this will happen. So while it is certainly something that's going to come up in the hearing and the board is going to ask for an explanation about this, if they hear an explanation that seems plausible, like I did this because everyone on the range was doing so, and I wasn't willing to put my safety in jeopardy to just make some point like that, I won't, break this rule, then their board is not likely, in my experience, to give too much weight to that factor in thinking that it predicts a person's risk of criminally offending when they're out in the community, right?
Hmm.
Like, there's a bit of a disconnect there between the idea that I did something to survive in prison versus the likelihood of you committing a crime when you're out in the community.
Yeah.
So, again, fair game for the board to ask about, but probably not something that's going to get a lot of weight at the end of the day. And this might be a good opportunity to go back and answer your question about the things that happen when a person is young, because
Yeah.
it's really the same kind of situation where certainly that's fair for the board to inquire about. If what was your youth like? What were you up to? If that is full of criminal activity versus an uneventful pro-social childhood, I mean, sure, that's fair for the board to ask about, but there's a difference between something that's that's not clearly irrelevant to assessing risk, and how much weight that
Hmm.
factor or that historical incident should be accorded in assessing someone's risk of future offending. The further back that goes, I would suggest on the face of it, the less relevant that's going to be. But also, like on the flip side, if you're looking at and examining a pattern of consistent behavior that goes all the way back to someone's youth, I mean, that is fair game to consider as you are trying to predict their risk of offending going forward. So the datedness of it and the context of it really does matter. As to how much weight it's going to get from the board in any given case, I mean, that's really going to be dependent on the circumstances and also what's happened in the intervening time, right? So, like, even if someone has a historic wrong, a misconduct, or a criminal charge prior, or even during the current sentence, if those things happen prior to them engaging in, several months long rehabilitative program in the prison system, I think you can make the argument that maybe that's not who they are anymore. And that very much is like the approach that I use in parole hearings, is to try to help the parole board understand who is this person that sits before them today, and hopefully get them to see that that is not the same person in important fundamental ways as who this human being was when they were committing those offenses, right? That's going to be some time ago, probably some number of years ago,
Hmm.
and people can change. Like, that is
Yeah.
what our system is founded on, is the idea that people, and really anybody, can be rehabilitated. So when they've put in the work and shown by doing programming and then demonstrating better behavior over time, we try to show that to the board and help them understand that this is not the same person as who committed those offenses. That person who was, in the immediate wake of committing those offenses, certainly we would not consider their risk to be manageable. But some number of years later, that is not the same person.
And some programs later, and lots
Exactly.
of like that, all of that has an impact. Otherwise, why are we
Absolutely.
wasting time creating these programs if we
Exactly.
don't believe that they have any kind of impact on a human
Right.
being? One thing that we were discussing before we started recording, Simon, is the Maplehurst incident, because that was ho I'm hoping this is not something that happens often in jails, but that was a very shocking incident when we saw these videos, and it was a very horrific way in which the inmates were treated at Maplehurst. Now, does an incident like that, when and if it does happen, and someone gets to experience that while they're serving their sentence, can that be used as a factor at all during their parole hearing to kind of gain points or
Mhm.
mitigate or just to
Yeah.
argue in favor of getting parole?
Yeah, that's a good question. So, just for context, for those who aren't familiar with it, you're talking about an incident that happened. I think it was in 2024, if I'm not mistaken, at Maplehurst Correctional Complex in Milton, where there was, you know, prison staff there retaliated against
Hmm.
inmates. For some incidents that had
Yes.
happened that involved some really abusive treatment, things that judges have said, essentially shock the conscience of the community to hear about, things beyond the pale of the proper way of disciplining inmates. And so the question is, how does that relate to a person going for parole and their releasability? Because obviously something like that is relevant when a person, if it happens to a person while they're in custody awaiting sentencing. So for a person who doesn't get bail on their offense,
Yeah.
that kind of harsh treatment or state misconduct even against them, or even just like not intentional misconduct, but harsh conditions in prison that are beyond the norm of just what prison is, can be factored into a sentence and can ultimately be a factor that mitigates and lowers a
Exactly.
sentence
Yeah.
because of the treatment, because the judge is responsible for, crafting an appropriate sentence for this offense and this offender, and it matters like the experience and the quality of the time that they are doing, right? If it is harsher, then the sentence has more of a punitive impact. It may not need to be as long, right? So in a principled way, judges can and should take things like that into consideration, because their task is this broad balancing of, different competing factors, including punishment and rehabilitation, and even addressing state misconduct, whether it rises to the level of a charter violation or not. All of that can and should go into assessing what the appropriate sentence for this offender and this offense is. Now, it's not the same in the context of parole. It's just not. Like that, these factors
Yeah.
do not get taken into account, directly speaking, in the context of parole. And the reason why is because the legal framework for what the board has to assess is so much more narrow. It is basically just, does this person present an undue risk to society, right? Is their risk manageable? Yes or no? And the paramount consideration for the board is public safety. This is enshrined in the statute, and there's no way around that. And there isn't enough flexibility in that framework to address things like harsh conditions or even intentional state misconduct against an inmate. That is not going to be factored in because, I mean, the parole board's perspective on this would be, well, how does that mitigate their risk of offending? I mean, they can't let the person out to send a message to the state that you can't treat people like this. That might be something a judge could do, lower a sentence to send a message to the state because the framework is broad enough to allow for that. The framework is not broad enough to allow for that in the context of parole, so they can't take that factor into account. Now, that doesn't mean it's totally irrelevant. Like, if I have somebody who has suffered misconduct in prison or who has experienced very harsh time, say on
Or
account of a
like
physical
COVID, for
disability,
example.
or
Like,
people during COVID,
yeah,
I would make this argument that the difficulty that they have experienced is something that the parole board can and should recognize, maybe factoring into their motivation, the offender's motivation, not just to get out. Of course, everyone is motivated
not
to
to
get out,
come back.
but
Yeah.
yeah, to be willing to do what is necessary to stay out,
Yeah.
which means abiding by your parole conditions
Yeah.
and abiding by the law.
Yeah.
And so I do think the board can consider something like that indirectly, and maybe the more terrible the experience for the person was, the
Exactly. Yeah.
more the board can believe this person can be trusted to do whatever is necessary to stay out. But it's not taken into account in the same way judges do, which would be to, like, grant a remedy to send a message. That doesn't happen in parole.
Which is unfortunate because, um, I mean, there's nothing more traumatizing than experiencing time in prison. And when there's something that happens, an incident like that, that especially when it's a very shocking incident, it just feels unfair not to take that into account, or that,
Yeah.
or not to give, even if they do take it. I mean, they probably will take it into account, but they won't maybe give it that much weight. It's still unfortunate because it's part of the experience, the jail experience, and how much it's going to, like you said, impact them and drive them not to want to come back.
Yeah.
And they'll do everything so that they can avoid going back.
Yeah.
Uh,
There's an expression that I don't know. I don't remember where I
yeah.
came across this expression in my career, but certainly one that I think rings true, which is that people go to prison for punishment. Sorry. People go to, I'm going to state it wrong. People go to prison as punishment, not for punishment, right? Going to prison is the punishment. You don't go to prison and then get treated harshly or cruelly or beaten or whipped as punishment. Like, that is not what you're there for. It is the experience of being in prison. That is the punishment of being separated from society and from your family. And that is the punishment. So really, I mean, that should be done in a way that is as humane as possible and as least restrictive and punitive as possible to accomplish the purposes of incarceration, which is, effectively separating people from society, regulating their behavior while they're in, and providing, rehabilitation with the view towards them returning to the community. I mean, that's what it should be about, not that while you're there, you can get this extra punishment by being treated harshly or physically abused by somebody. That is just
Mhm.
not what going to prison as a punishment means. So, yeah, it is quite disturbing that there isn't really some way for that to be taken into account, like there is on the front. If it happens on the front end, it can be taken
Sentencing.
into
Yeah.
account in sentencing. I mean, there is legislation that has been put forward in the Senate, I believe by Senator Kim Pate, who is a prison law advocate, frankly, who is trying to get there to be a change in law where that can be recognized, that if horrible things happen to somebody while they're in prison, like beyond just being in prison as punishment for your offense, that can be taken into account some way, like specifically by, say, reducing a sentence as recognition for that hardship. But currently there's no way to do that. And that seems kind of like a gap in our sentencing legislation, because because, judges send people to prison for a certain length of time with expectations about what that will look like, that it will conform to, the standards and norms of our society, and that people won't be, corporally punished or abused or sexually assaulted in custody. And if those things happen, I mean, maybe it is appropriate to revisit that sentence because it is not what was intended by the judge when they sent them there thinking that they would be treated, humanely and kept safe. So I think something like that is principled and appropriate for us to have, and we don't currently have it.
So one last area that I want to touch upon, Simon, is the other challenge as well is the programming, because one of the things that the parole board is going to consider is, well, what have you been doing while you were incarcerated, and did you take advantage of some of the programs that are available? Now, the issue is, though, I don't think every place has the same kind of options that are available. There could be some other barriers, for example. What about people who have language barriers who can't really benefit from the programs? So, I mean, it is unfair. Like, if you don't have that many opportunities available, or if there are opportunities, but because of your circumstances, you can't really take advantage of them. So, can we just talk a little bit about that? Because I think it's pretty
Sure.
unfair as well for
Yeah.
the.
That's a real challenge for me in the work that I do. And most of my clients face this at some point in their sentence. So, for those serving time in the provincial jail sentence with sentences of less than 2 years,
Yeah.
there's almost no rehabilitative programs offered in the provincial jail system. So that can be challenging because they're not being provided with these opportunities to rehabilitate themselves. I mean, there are some self-directed workbooks that they can do, and maybe
Hmm.
some support groups like Alcoholics Anonymous or Narcotics Anonymous or something like that,
Right.
but it's very limited in the provincial system. There is more formalized programming in the federal prison system. They have something called the ICPM program. It stands for Integrated Correctional Program Model, and it's kind of like an amalgamation of a bunch of different specific programs that they used to have that they just deliver in a standardized format now. But it is difficult because it's like a group setting, and not everybody's comfortable to interact in a group setting. And also, it's the bigger problem is that it's just there's not enough resources to deliver this to people in a timely fashion. So there are wait lists for the ICPM
That's
program
what I
at
was going
every
to ask. So,
institution. And
yeah.
people get stuck on these wait lists for months and months and months as their parole eligibility dates come and go. And, the Correctional Service of Canada will try to get these people their program before they are kicked out on their statutory release, most of them anyway, kicked out on their statutory release. But the number of people who get it before they reach their parole eligibility date, which is what ideally it should be, and what the target of the correctional service is very, very small, particularly for those serving sentences of anything less than 5 or 6 years.
Yeah.
I mean, if you're serving sentences in the high single digits or double digits, you're probably going to have enough time to get your program done before your parole eligibility date. But if your parole eligibility date is coming up in 14 months or 20 months or something like that, or 2 years, you're not likely to get that program in time to go for parole when you are eligible, which leaves you with the unenviable choice of having to sort of decide to go for parole nonetheless, being viewed by the parole board as an untreated offender because you haven't done the programming that has been recommended for you to do, or delaying going for parole to get this program done. And sometimes they can't even tell you when you might get the program because the list is not first come first serve. It's a revolving list. It's a triage type of list where people who come into the institution after you who have a shorter sentence might get higher priority for you than you, so you can get bumped on the list and just have this moving target of when you might get your program and just be expected to what? Wait, and then, oh, your statutory release is here, and you never even really took your chance for parole. I mean, I think that that's unfair based on, for that to happen based on a shortage of resources. I mean, I realize the Correctional Service, like every institution, does not have unlimited resources, but it is a real and current problem for most inmates. Now, not every inmate, I should say, gets recommended for programming. Some do, some don't. But for those who do, and many do, this is a real challenge, and one for which there is essentially no remedy because, again, the parole board can't take into account why you didn't get the program, i.e., lack of resources on the part of the correctional service, and they can't factor that into their risk assessment for you in any favorable way. They can't release you if your risk isn't manageable because you haven't done the program just to send a message to the correctional service. That would be compromising public safety. We don't do that. So there isn't really any remedy for these people. And there really, to be honest, isn't any incentive for the correctional service to do better here. I mean, they're not getting punished in any way. People aren't getting released, and the government or the public is angry about why did you let this happen with your misconduct, like they might be towards the police if cases get tossed or sentences get reduced because of police misconduct. I mean, that's a thing that is supposed to apply pressure for there to be change, either pressure on the service, pressure from the government, from the public. And there's no corollary to that in the parole system. The board can't give you credit for something you haven't done. Now, that doesn't mean that they're punishing you for not having done the program. It just means when they do their risk assessment, there's no program for them to give you any credit for having done credit in terms of like rehabilitative,
Yeah.
efforts and things like learning knowledge and skills that are supposed to help you do better in the future. That hasn't happened yet. And so you're at a real disadvantage to go for parole without your programming, something you have no control over. I mean, my clients all want their program. They're clamoring for their program. They're writing requests. Please get me my program.
Yeah.
They want to be rehabilitated. Like, again, for people who want this, surely we should be trying to deliver these programs to them. And I mean, to be fair, the correctional service is trying, but they're not succeeding in a timely fashion. And sometimes people get frustrated with that, and then they get disillusioned. And then when they're offered their program some number of months or years later, by this time they've stopped caring. And that's a loss for all of us if that's something that happens.
Well, I mean, one other way, one other solution is also to reduce incarceration, right? Like that would be a good way also to deal with the overpopulation of the jails. Because if there's one thing that we've noticed, especially in Ontario, is that all the jails seem to be overpopulated, and there isn't enough space. And obviously, when there isn't enough space, there isn't enough programming available for everyone. So hopefully we'll I mean, I like to be optimistic. We'll get to a point where maybe we'll have less people maybe in prison or just a manageable number so that, like everyone can have the same opportunities because it is unfair if someone has to make a decision to maybe skip their parole hearing, their first one, just because they didn't have a chance to do some programming. It's really sad. It's a sad state of affairs. So
Mm-hmm,
hopefully,
mm-hmm.
like this can be addressed.
Sure. I mean, there's yeah, I don't disagree with you that, reducing the population of people in prison would be helpful in the sense of focusing the limited resources we have on those who need the most. Like
Yes.
to be candid, like I'm not a proponent of prison abolition and saying that we shouldn't incarcerate people. I mean, there are sometimes I think people need to be separated from society. They
Yeah.
need to have that time out, and there needs to be a place for them to go.
Yeah.
And prison may not be the perfect place for it, but it's kind of the way that our system works. And I don't know in a lot of cases, what would be a better place for them. So I think focusing the resources on those who need it the most would be helpful. That means, getting more people out on parole or allowing them to go for parole at the time of their eligibility without creating artificial barriers like programs that don't get delivered in time. I mean, the more people that we can get through the system, get in front of the parole board, recognize that, okay, you don't need to be here anymore. Your risk is manageable. You go into the community. Now we can focus those resources on
Yeah.
those who remain, who really, frankly, need it more. I think that's what can be done within the prison system. I mean, certainly on the criminal justice side of things, the sentencing side of things, we can look at alternatives to sentencing. Is a prison sentence warranted, or a jail sentence warranted,
Well,
or
and
perhaps
especially
could
when it's less than a year, like if it's for 60 days or
right,
90 days,
right,
there
yeah,
can be alternatives to that. You don't need to put them
exactly.
and take time and space for the 60 days, 90 days. Like this is just, and especially if the judge is not agreeing to a conditional sentence, I
Hmm.
think it's a little bit ridiculous, like because it takes a lot of pressure off the system. And like you said, Simon, like these resources should be focused and given to those who really need them. We can't
Hmm.
just waste them on everybody just like that. Like, yeah.
Yeah, yeah, for sure. I mean, look, there, like I said, I acknowledge the correctional service in the provincial jails as well have limited resources, and I don't think anybody wants to pay more taxes for necessarily more
Exactly.
resources
Yeah.
to go to this. So we have to work with the limited resources we
Yeah.
have, and that means being judicious about it, about how who we incarcerate, how we incarcerate people, for how long do we
Yeah.
incarcerate them, and how do we funnel them out of the system in a way that is fast and effective and doesn't compromise public safety. Like, I am not advocating for releasing people who are a risk to public safety. Like, I live in the community like everyone else. Like, I don't want this. Nobody wants this. But I think that there are ways that we can approach this in a way that doesn't compromise public safety. And that's one of the things that I want people to understand and take away a message about parole is that
Mhm.
people aren't getting parole who are a risk to the public,
Yeah.
like any more so than it's true that people who pose a significant risk to the community are getting out on bail. That is a myth. That is a falsehood, that our system of bail is so broken that we're letting out all the most dangerous and violent offenders. That is not true. There is the legal system that we have for bail. The legal test considers risk to the public. It considers other factors as well. And it is simply not the case. And anyone who works in the bail courts or works in parole knows that judges in the case of bail, or justices of the peace, or parole boards in the case of parole, are not letting people out who are clear and obvious risks of violence. That doesn't mean that they get every decision right. And certainly you can see, high profile examples where someone with a record got out and committed another offense.
Yeah.
And you can debate whether it was right or wrong for the person to be released in that context. But I don't know of any judges or board members who are sort of cavalierly releasing people who are a threat to the public. That's just not true. And we can't take from the fact that judges or justice of the peace or parole board members may sometimes get their risk assessment wrong to mean that the system is broken or that judges and parole board members are doing something like this cavalierly. It is just not true.
And on the other hand, there are a lot of people who sometimes shouldn't even be incarcerated, are there, and they're wrongfully either convicted or their sentence is way too harsh. So it's not just the error is not just on the side of letting people loose who shouldn't be out, but it's also on the other side as well. So that's also something that people don't always think about. But Simon, I want to thank you so much. This was, as always, very interesting. I always learn so much from you about this whole prison and parole world. So thank you so much, and hopefully we'll continue this conversation and talk more about other subjects that are related to prison law and parole. So
For
thanks
sure. Yeah.
again.
Thank you so much for the opportunity. I always love speaking about anything prison law related. It's something I'm very passionate
Yeah.
about, and something that I really want people in the community, both lawyers and non-lawyers, to know more about and to understand better what this is and why we have it and why it works the way that it does. Because in my view, it is a principled and fairly sophisticated approach to things. It may not be perfect, but I think we have a pretty good system that balances individual rights with public safety in a way that makes sense. And I want people to know that and not think that this is some kind of get out of jail free card or sympathy towards offenders or light on crime. That's simply not the case.
Yeah.
So I appreciate the opportunity to talk about this.
Thank you so much, Simon. And
My pleasure.
I'm sure that a lot of people will learn a lot from this interview. So thank you again.
My pleasure. Thank you.